This case occurred in the early 19th century when the Royal Post was still the most efficient means of moving information across long distances, and it formed the basis of a contract rule called the Postal Acceptance Rule, which remained important right up until the arrival of reliable, secure internet. In Adams and Lindsell, the parties were organising the sale of 800 tods of wool. A tod was 2 stone or 13 kilos, so we're talking about more than 10 tonnes of wool. The defendants offered the wool to the plaintiffs and set a price and said they wanted an answer in course of post. Now, they posted that on the 2nd of September, and if the posts had run efficiently, they would have expected their answer on the 7th. The 7th came and went, and there was no response, so they sold the wool to another buyer. It turns out that instead of sending their offer to the plaintiffs in Bromsgrove in Worcestershire, the defendants addressed the offer to another town called Bromsgrove in Leicestershire. It therefore didn't arrive with the correct addressee until the 5th of September, but they immediately wrote back accepting the offer. Their acceptance arrived on the 9th of September after the defendants had already sold the wool to another buyer. So the question was there a contract? Well, the court found that there was. The court found that when you send an offer to someone by post, the offer is made continuously while it's in the post, and the offer is accepted in this case by sending the reply. Once the reply was sent, there was a contract, and the plaintiffs were now entitled to their 10 tonnes of wool. However, the court in this case also seemed to be saying that one reason they'd decided in favour of the plaintiffs was because the defendants had mucked it up and sent their offer to the wrong Bromsgrove. It wasn't until a later case called Henthorn and Fraser that the court finalised the postal acceptance rule by saying that acceptance of a contract is binding where and when the acceptance is posted, provided the parties both understood that the post would be a valid way to accept. 200 years later, the internet has largely done away with the practical use of the postal acceptance rule, but it still remains the law in Australia.